Hey, thanks, Sam, and thanks to all of you for tuning in. Let's turn over to page 1 of the materials. We're going to talk about loan originator compensation today, but the program is also going to cover some strangely located provisions that relate to the SAFE Act. They stuck those in Reg Z. Why? Because Dodd-Frank told them to do so. So we're going to cover both of them because they came out during the same rulemaking. I would note that the definitions of loan originator for Reg Z comp purposes is a different definition than the definition of mortgage loan originator for purposes of requiring registration under the SAFE Act, and the triggers for requiring registration under the SAFE Act have not changed, but some of the other things have changed. We've been dealing with loan originator compensation issues for quite some time now. They came out with the rules that became effective in April 2011. This is kind of an evolutionary process, and one of the things that occurred after the April 2011 rules was the determination by the regulators that, oh yeah, this affects how you can make contributions to benefit plans for loan originators, and it affects how you pay bonuses to those folks. So now they've come back and they have tweaked the rules, they've clarified some things, they've changed some tests. So we're going to discuss during the program how to determine when a factor or proxy that is used to determine loan originator compensation is a term of a transaction. Why do you care? Because a loan originator's compensation cannot be based on a term of a transaction. We're going to sketch out how contributions can be made to 401k plans for loan originators and how bonuses can be paid to loan originators without violating the rules. And then we're going to talk about what they've done with respect to SAFE Act-related provisions. And we're going to talk about what you need to be looking for when you're doing the background checks, how different elements in a person's background may render them unqualified to be registered as a SAFE Act mortgage loan originator. We'll talk about some additional disclosure requirements for loan originators, and we'll talk about what you need to do in the way of written policies and procedures. Reg Z is now under the Consumer Financial Protection Bureau, so the rules we're going to be discussing today are ones that emanated from the Bureau. They implement changes that Dodd-Frank made to the Truth in Lending Act, and they come in Subpart E of Reg Z, which are the special rules for home mortgage transactions. Thank goodness we have amendments to the official staff commentary, because that's where we find a lot of helpful information that expands upon the bare bones information contained in the rules. Let's go ahead and talk about record retention requirements first off, get that out of the way. Over on page 3, there are really two sets of requirements for record keeping on loan originator compensation. The first set of requirements is on creditors. And creditors are required to keep records of what the creditor paid as compensation to each covered loan originator. Plus, the creditor has to keep the compensation agreement that governs those payments. And those record retention requirements have a 3-year time span, and it's 3 years after the date of payment. The second set of requirements is on loan originator organizations, and we'll get into that definition in just a moment. But a loan originator organization has to keep records of compensation it receives from anybody pretty much, a creditor, consumer, or another person, has to keep records of compensation it pays to an individual loan originator. And again, that's a specially defined term that we'll talk about. And it has to keep the compensation agreement that governs the each receipt of payment or each payment the loan originator organization made, and that too is subject to a 3-year record retention requirement. In terms of determining whether the records you're keeping are sufficient, because they have to be sufficient to evidence the compensation and the payments received, you're going to be keeping records that show the nature and amount of the compensation. And keep in mind that the compensation doesn't necessarily always mean cash compensation. It can mean trips. It can mean other things. You're going to keep records that show who paid it, who received it, and when the compensation payment was made and when it was received. In terms of specific records, you're going to keep the compensation agreements themselves, but you may need some additional records, and what you keep is going to depend on the facts and circumstances. So if you turn over to page 4, let's look at some different examples. And over on the left-hand column, we look at, okay, what was the nature of the compensation? Because they say you've got to keep track of the nature and amount. So in this case, first of all, let's look at what you keep if the compensation was in the form of salary. Well, you're going to keep the things that you file with the Internal Revenue Service, for example, so W-2s, 1099 miscellaneous forms, things of that nature. If you are keeping records on contributions that were made to or a benefit that was made under a designated tax advantage retirement plan, and we're going to talk about what that is, then you're making filings under ERISA, and your filings that you make under that show the names of the loan originators that were covered under the plan and so forth will be sufficient. If it's a commission or bonus, then you're going to have a settlement agent flow of funds worksheet or some other written record, or maybe it is closing instructions from the creditor that say, okay, at closing, here is what is to be paid to a loan originator. And if you have a state law that requires there to be a disclosure of compensation or broker agreement, you're going to have that kind of record. Some of you have those state laws, some of you don't. And then if you have a situation where there is a possible respite tolerance violation and the compensation for the loan originator has been decreased in order to compensate for that in a situation where it was an unforeseen increase in an actual settlement cost over what the estimate was, then you're going to have a record of the fact that the compensation was decreased, because your compensation plan is going to show that it would have been something different. So you're going to keep a record showing that the compensation was decreased and a record that indicates why it was decreased. Now, not all compensation agreements are in writing. So over on page 5, the regulation makes clear that when they talk about keeping records of compensation agreements, they're using that term in a broad sense to include any agreement, whether it's oral or written, or based on a course of conduct. And when you're talking about a course of conduct, you're basically talking about something where you can say, well, that's the way we do it, and everybody knows